We think powers of attorney are the most crucial estate planning documents people can have during their lifetime because you want to appoint somebody to make decisions for you if you can't make them yourself. Without powers of attorney, there may be a gap in decision making. You might even have to get the courts involved about making decisions for you. There's some terminology that's very specific to powers of attorney. The principal is the technical term for the person who creates the power of attorney. The person who's given authority under the power of attorney is usually called an agent or an attorney in fact. Now, the reality is that 99% of the population, they look at their kid who they've named as their agent and they say, oh, that's my power of attorney. That's how most people think about it, but technically it's either agent or attorney in fact. Powers of attorney are typically, not always, but typically divided into two subject matter areas. There's one that covers healthcare, and there's one that's called a general durable power of attorney that covers almost everything else. Most people think of that as a financial document, but it really has very broad powers outside of healthcare. In Washington, in order to create a valid power of attorney, it has to be in writing, signed by the principal, and it has to be either witnessed by two independent parties or notarized, although the law does give a little more power and authority to a document that's notarized. General durable power of attorney can be made effective in one of two ways. It can either be effective immediately or upon disability or incapacity. If it's effective on disability or incapacity, it's really a dormant document until someone is able to provide a note from a doctor or another healthcare provider that you are unable to make decisions on your own. A general durable power of attorney can also be made effective immediately. The situations where we use this kind of effectiveness vary, but a common situation would be an aging parent who still is able to handle their own affairs, but wants some assistance from one of their kids. My mom had this exact situation. She was still totally competent, but she wanted me to be able to talk to her insurance agent and talk to her financial advisor. And so we made her power of attorney effective immediately. It didn't take any authority away from her. It just added me as another person who could help her. When thinking about who's going to be your agent under a power of attorney, the most important thing is, who do you trust? Who's going to make the decisions that they're directed to make and that you want them to make? It's also really important to name backup agents, not just maybe having one backup, but having a backup to the backup. Just because you name somebody as your agent under a power of attorney doesn't obligate them to serve. They might be unable to serve for their own life reasons, or they might say, I just don't want to do it. In that case, you need to have someone who can step in behind them to serve as the backup. And like I said, then maybe even a backup to the backup. If a person doesn't have a healthcare power of attorney, all is not lost. The state statutes do lay out a tree of decision makers under the informed consent statute that make decisions for you if you can't make them yourself. So the spouse is the person with the first priority, children would have a second priority, parents and then siblings and so forth and so on down the line. The problem can become, however, that all people in a class have equal decision-making authority. I've been told, I'm an only child, but I have been told that siblings don't always agree. And if two of your kids disagree about your health care, then you're stuck.